Good day to everyone. My name is LING, 21 years old. I was born in Cebu, Sarawak, and currently I resided in Batu Pahat, Johor. Before I studied law at UNIZA, I was a former STPN student at High School Batu Pahat. Through my journey of studying law, I look forward to learning, developing, and being able to apply the laws to solve difficulty and issues that arise in my life or surroundings. As the saying goes, knowledge is power, and I hope to be able to utilize my law skill and knowledge in any professional or personal area to assist the community or even my friends and families with their legal concerns or dispute. That's all of my little self-introductions. So I was provided with a situation involving a dispute between two parties. Therefore, in this video, I will present a legal opinion on how to resolve the issues in the given situation by utilizing the knowledge I had gained throughout this semester. The dispute is between Andika Benadi, who was the seller of the albums, and Atika, who was his potential buyer. I found that there are three issues in the case. Firstly, we're going to determine the validity of Andika Benadi offer to sell 3 albums collection of LING to Atika at 1,000 ringgit Malaysia. According to Section 2A of the Contracts Act 1950, a proposal can be defined as the action made by a person to notify another of his willingness to do or to abstain from doing something with the purpose to obtain the assent of the person to the act or acceptance. Section 4, Subsection 1 of the Act stated that an offer is only valid when it is communicated to the offeree. In this particular case, Andika Benadi, the seller of LING 3 albums collections, had called Atika and made an express offer to her to purchase the collection for 1,000 ringgit Malaysia. Andika Benadi's offer is valid as its communication is complete when he, as the offerer, had called Atika and the offer was come to the knowledge of Atika, who was the offeree. Let's move to the second issue, whether Andika Benadi's offer to Atika had been revoked or not. According to Section 5, Subsection 1 of Contracts Act 1950, a proposal may be revoked by the offeror at any time before the offeree accepts the offer. Meanwhile, Section 6, Subsection 1 provides that a proposal may be revoked by the offeror giving notice of revocation to the offeree. Lastly, Section 4, Subsection 3 under Contracts Act 1950 stated that the communication of a revocation is complete as against the offeree when it comes to his knowledge. In this particular case, Andika Benadi, the offerer, forgot to inform Atika, the offeree, about the albums were unavailable until she called him on 20 June morning. As a result, Andika Benadi did not deliver the revocation notice to Atika since he failed to notify her of the revocation of his offer before she called to make acceptance. Now we come to the last issue of the case, and we have to determine whether Atika was making a valid acceptance on 20 June when she already knew about the non-existence of the albums from her friend on 19 June. According to Section 2B of the Contracts Act 1915, acceptance is defined as the acceptance agreement expressed to word or conduct, and when accepted, the proposal is said to transform into a valid promise. Other than that, based on the Section 7B, if the proposal specifies a method for indicating acceptance, the offeree must use that method. In our current case, Atika, as the acceptor, failed to make the acceptance through WhatsApp, which was requested by Andika Benadi at the time when he communicated his offer to Atika. Instead, she just called him through phone call and did not follow the exact manner prescribed by Andika Benadi before. In addition, despite knowing that the albums were no longer available, Atika insisted on accepting the offer. Andika Benadi had accepted Atika's friend's offer to sell his albums before Atika's acceptance. As a result, Andika Benadi's initial offer to Atika was no longer available, and Atika had been aware of the non-existence of the album since 19 June. Therefore, the offer was no longer available and open to Atika to accept. To conclude, Andika Benadi was making a valid offer to sell 3 albums collection of LING to Atika at 1,000 ringgit Malaysia. However, Andika Benadi failed to terminate his offer to Atika since he failed to notify her of the revocation before she made a sentence on 20 June. Alternatively, Andika Benadi should immediately inform Atika about the non-existence of the album to effectively revoke his offer. Finally, Atika's acceptance to Andika Benadi's offer was invalid since she did not follow the prescribed manner specified by the offerer. In addition, prior to the call, she was aware that the album was no longer available and the offer was no longer valid and open for her to accept. Therefore, there is no binding contract between them. That's all from me. Thank you for watching and have a nice day.